let's talk about some frequently asked questions along the theme of when does VA need to assist a claimant? What duty does VA owe to claimants? We have a ton of questions in this segment, and we're going to try to address them pretty quickly because there are a lot of nuances specific to the unique non-adversarial VA system. If you don't know what that means, we're going to get into it. But we thought that this would be helpful to answer the question of, to what degree is VA required to assist me if I'm filing a claim or appeal? Claire, first question's for you. And I think it's a good one because I've used the term already. What does non-adversarial mean? What does the pro-claimant benefit system refer to?
So adversarial generally means you have two opposing parties. So this is typical of litigation settings. But the VA claims process is different. It's non-adversarial. So when a veteran's filing a claim for disability benefits, it's not supposed to be VA versus the veteran. VA is not supposed to be the claimant's adversary. They're supposed to work with the veteran to make sure that it maximizes their benefits. Mm-hmm. The next question, does the VA claims process become adversarial at any point?
Good question. At the agency level, no. But at the court, yes, because once a veteran needs to appeal an adverse decision from the highest tribunal within the agency, which is the Board of Veterans Appeals, then the matter needs to proceed to the CAVC. And if you're at the CAVC, it becomes a case of the veteran versus the secretary of the VA. So in that sense, it's more traditional litigation where the Office of General Counsel represents the interest of the government, and someone like us at CCK will represent the interest of the veteran. That process is adversarial, but at that point, the court is just looking at, they're in appellate review mode of everything that's happened at the agency. The agency process, when evidence is being submitted and the duty to assist applies, another thing we'll talk about in a minute, that process is not ever adversarial. Claire, what are reasonable efforts to gather evidence? What does that look like? And this is a term that is thrown around because VA has by law an obligation to reasonably assist, take reasonable efforts to help a claimant.
Yeah, so this means VA has a duty to obtain evidence like service personnel records, service medical records, private treatment records that a veteran might identify for a condition. And reasonable efforts, that means that they have to make more than one attempt to get this evidence. They have to make at least 2 attempts. They have to verify whether or not the evidence exists. And they have to notify the claimant how the process of gathering evidence is going and give the veteran an opportunity to participate in that evidence gathering process.
And these are hallmark features of what I should have said a minute ago, the duty to assist.
Yeah.
So generally speaking, just like what Claire described, the duty to assist means that VA has an obligation to make reasonable efforts to support, to assist a veteran in substantiating their claim. In other words, when a veteran files a claim or an appeal at the VA has some obligation to, if it has knowledge of records that might support the claim, if it needs medical information, because of course adjudicators are not doctors. So if the question involves a medical question, VA has a duty as an agency to help veterans and assist veterans in the prosecution of their claims and appeals. That means that they need to take steps to do the things that Claire just identified, make reasonable attempts to obtain supportive records. There are also other things we'll talk about in a minute that are covered by this duty to assist. But it is a unique feature, like I mentioned before, of the VA system. A veteran, if they're not represented or if they do not have evidence to submit with their claim, VA has some obligation to kick in with some assistance along the way. You talked, Claire, about reasonable efforts to gather evidence like private treatment records or service records. Can you talk a little bit about exams?
Sure. So there is the VA medical exams under the Veterans Claims and Assistance Act, or VCAA, of the year 2000. If an examination from a medical professional would help to substantiate a claim, and VA has an indication that that's the case, VA has a duty to provide that examination. So, for example, if a veteran has a documented injury or incurrence of a disability in service, if they still have that same disability or incurrence in the present time, and they identify an indication that their disability may be related to that in-service injury, that's enough to trigger VA's duty to get an examination. So VA has contracted examiners that they hire to perform these examinations, and they'll ask the medical doctor to give an opinion as to whether it's at least as likely as not that the in-service event and the post-service disability are connected. So, as a veteran seeking benefits, you should identify all of the helpful information that you can to kind of give VA enough that it can trigger its duty to assist. VA will typically look for evidence that you have a disability, that you've identified an in-service event or injury. But this is a low bar. Mm-hmm. Any kind of indication that the disability could be related, it's intentionally a low bar so that veterans can have, the most fair, well-developed evidentiary record so that VA can make the best informed decision.
Exactly.
So switching gears a bit, what does the duty to assist look like at a hearing at the regional office?
Good question. At a hearing, the hearing officer at the regional office or the veterans law judge at the board, regardless, there is a duty to explain to the claimant appearing at the hearing what law applies. So the elements of the claim that they're trying to prove or the specific regulation that might govern the increased rating request. The hearing officer or the judge presiding has to explain what law applies to that claim or the issue that's being heard. There's also a duty to describe what evidence could help to support the claim, similar to the duty to assist that we talked about. But these things need to be identified on the record at the hearing so that VA knows that the claimant is being assisted in that way. They know what they have to prove at the hearing. And also, if the board is conducting a hearing with the claimant and the hearing reveals that there is outstanding evidence that could be supportive of the claim, then the board needs to ideally remand the case back to the regional office. The regional office is the tribunal that would be responsible for gathering evidence. So if the board has reason to think that there's helpful evidence out there, it really should be remanding the matter back to the regional office to do that duty to assist development with the veteran. What happens, Claire, if VA doesn't satisfy the duty to assist?
Well, we do see this often. One of the things about the duty to assist is that VA's obligation doesn't just stop at getting an exam. They have to actually get an adequate exam. And often we find that the exams and medical opinions that they obtain are not adequate. So we might submit an argument explaining why an exam is inadequate. A huge common mistake that we see in exams is an examiner will just kind of talk about a disability in general. They'll say degenerative arthritis is age-related. It's due to wear and tear. It could, they might say that a condition could be genetic or it could be due to age. They'll talk generally about a condition and they won't talk about the specific veteran sitting in front of them and how those factors might be related or not related to the veteran. They might not consider a veteran's lay statement. They might not consider favorable evidence in the record. It runs all kinds of directions. And so we might, and often we do, argue that VA hasn't discharged its duty to assist because the exam that it got was not adequate. And we'll articulate maybe VA is failing to obtain evidence. Maybe they're looking for an event in service and they're not looking as thoroughly as they could. And we will explain why this failure is harmful to our client and make those arguments either at the regional office or at the board or even at court. We'll explain to them why they need to go back and really exhaust their duty to assist efforts. So one thing that we talk about a lot in our arguments and our cases is that the benefit of the doubt doctrine and this term equipoise. Can you talk about what that means?
Yes. The benefit of the doubt doctrine essentially means, I think the phrase that we often use is that the tie goes to the veteran. So if the record contains some positive, some negative, some favorable, some unfavorable evidence, if ever there's that status of equipoise or equipose, I'm actually not sure how to say it. I've heard it both ways. If the evidence is an approximate balance, let's say, then VA needs to grant the claim. VA needs to side with the veteran. If there's ever a question as to whether the benefit is warranted, and there's other layers of the VA process that speak to this, then VA needs to award the benefit. And this is an example that goes back to the non-adversarial nature. VA can't be looking for reasons to deny. They really should be looking for reasons to grant. I appreciate that there are people out there who are going to say that the benefit of the doubt doctrine doesn't really exist and it's just a theory and it is not something that you see in decisions that you get from VA. And I think that's a valid concern because it doesn't work as smoothly as there's some positive and there's some negative evidence, and so VA will grant the claim. We definitely don't see that happening in that very simplistic view. Can you talk, Claire, about kind of the weaknesses of the doctrine, or at least as applied? Do we see kind of like unique issues around this?
Yeah, I think it's, like you said, this is a theory. This is in the law. And the law in theory versus in practice, I think in our experience is very different. So it's a bit of a vague kind of doctrine to follow. It's hard to apply consistently across adjudicators. For example, a VA exam might be favorable, a second VA exam might be unfavorable. And it's hard to say how an adjudicator is supposed to, well, I think they should resolve the benefit of the doubt in the veteran's favor, but that adjudicator might not see it the same way that I do as an advocate, and they might assign more weight to an unfavorable exam. So it's difficult to set a hard line for when this rule should be applied. And, sadly, we obtain and help veterans submit favorable evidence outside of the VA system. So we might have an independent medical expert give an opinion. And unfortunately, VA will assign greater weight to its own VA medical opinion, which is most likely unfavorable. So we think that in practice, the benefit of the doubt rule is not always applied as it should be. But as with all of the laws, we remind VA of what they're supposed to do, and we persist in getting them to apply it. So how does this apply to an increased rating claim?
Functionally, it's the same as if it were a service connection claim. If there's some evidence that the veteran is entitled to the higher of two evaluations, let's say a 30% versus a 10% rating, if the evidence is kind of mixed, but if it's approximately balanced as to whether the veteran should get the 30 or the 10% rating, VA needs to err on the side of the veteran, tie goes to the veteran, and award the higher rating. The analogy that colleagues here have used is think about an elevator that's stuck between two floors. If you really are in the middle of two evaluations and you have evidence that shows that you exceed the 10% criteria, but maybe don't fully meet the 30% criteria, in theory, per the benefit of the doubt rule, VA is supposed to award you the higher of two evaluations. Just like Claire talked about, it's different in practice than it is in theory. That is what is supposed to happen. It's something that we can assert in arguments, just like Claire said. And that's what should happen in a perfect world. And the world is imperfect. So this is something that we do have to argue from time to time because VA gets this wrong.
Yeah.
Claire, what are VA's rules on favorable findings?
So this is a great result of the Appeals Modernization Act. VA has to list favorable findings in its decisions. So typically in a rating decision, you'll see some paragraphs of background, and then there will be a bulleted or numbered list of favorable findings. And what's great about these is they're binding on future adjudication. So in every subsequent decision, that favorable finding sticks. The only exception is if, and this is rare, VA finds that favorable finding was clearly and unmistakably wrong. So maybe they found that a veteran served in a location, and then later they determined that was wrong. That's the only scenario where they can overturn it. Otherwise, VA is bound by its own favorable findings, which can be really helpful throughout this prolonged, difficult process to pick up favorable findings as you go. It can help to cover that ground and look for those missing elements, and it can really narrow what you have to prove to prevail on your claim. Here's a topic that we see all the time, unfortunately. What is considered developing to deny?
This is a tough one. We do see this often. And I think folks out there who have dealt with the development process at VA have maybe experienced this in a way. Development to deny is a phrase that we use to describe when VA is going out and obtaining evidence when the record already, before they do that, contains enough favorable evidence to grant the claim. An easy scenario to think about is if a veteran wants to file for service connection for, let's say, post-traumatic stress disorder, they see their treating psychiatrist or psychologist, that doctor writes an opinion for them saying their PTSD is clearly related to their military service, and the veteran submits that with their claim and says, please grant me benefits. I have this doctor telling me that PTSD is related to service. If VA goes out and gets their own examination and it's negative, that scenario you might call a situation where VA is developing to deny. The question is, why didn't they just grant the claim when they had a favorable, assuming, that it's a competent medical opinion from a competent doctor? This can take a lot of different forms. If veterans are submitting evidence that's supportive, and then VA goes out and gets more evidence, whether it's a medical opinion or records or even some memos that VA can get on their end about exposure or any sort of thing, that's the scenario that is very frustrating for individuals who are feeling like, I've already submitted everything I need. Why do they need to go out and get more evidence, especially when what VA gets is negative? That's extremely frustrating for us, for veterans, of course, for their families. So this can also happen at the Board of Veterans Appeals, I'll say, where all the evidence that's favorable is in the record. The case proceeds to the board on appeal, but the board identifies some deficiency in the record and says that further development is needed for XYZ, and then they remand back to the regional office for more development. Incredibly frustrating. It takes a lot of time. It's also unclear as to why that would be happening when the benefit of the doubt rule exists and the non-adversarial process exists. So if a veteran is stuck in this situation, we recommend the following. If VA is asking for exams, even if we don't think they're warranted or necessary, we generally will advise to attend the exams. And the reason for that is because failure to attend an exam can result in an automatic denial. So on principle, even if you don't feel like you should have to go to the exam, even if we fully agree, there's not a different outcome if you don't go to the exam other than an automatic denial. And that can just create more headaches down the road. So if possible, attend the exam that's ordered, even if you feel like it's a development to deny type exam. You always want to be looking at any exam or medical evidence that VA is gathering, taking the opportunity to assert any inadequacies or deficiencies in that evidence, write into VA about why it's wrong, why it's premised on inaccurate facts, why it's not sufficiently reasoned, the opinion that maybe a VA examiner is reaching or the evidence that VA is gathering. If a private medical opinion supports your case and a negative VA opinion has been ordered, we argue this all the time, why VA should find in favor of our doctor, which is not what they're finding. They're finding in favor of a veteran, but sometimes it does kind of become a battle of the experts in that sense. So providing reasons why the private opinion is better can be helpful. And we've talked about this before, but I think a common scenario or a common perception is that VA has a tendency to favor the information that comes from its own examiners. VA should not be doing that because they should be favoring the evidence that is competent, that satisfies the legal criteria, regardless of who is authoring it. But this is a big, vast agency that conducts a ton of examinations through various contractors and through specialized forms that VA gives to those contractors. And so they know what those exams look like. They all kind of follow the same pattern. They have the same questions. The answers take a certain form. Raters at the VA know what that information looks like. They're very experienced with processing it because they deal with it all the time. And so in comes this tendency that I perceive, and I think that you probably perceive too, Claire, that VA will favor its own examiners over a private opinion. They can't do it just for the sake of it. They can't say, because it comes from VA, it's better. That's not permitted. And they also are not absolved from their obligation to look at all the evidence and evaluate it independently and on its own merit. But it is something that we have to address with arguments, sometimes with addendum opinions from private doctors who can address a VA exam. That can be very powerful too, to have a second look from a doctor at what a VA doctor is saying. So this is a tricky subject and something that, again, I said the word frustrating before, I'll say it again, an incredibly frustrating outcome if you feel like you've fully developed a claim and VA is going out and getting more negative development. But we hope that this discussion about the nature of the non-adversarial VA system is helpful to anticipate the ways in which VA does have a duty to assist the claimants that are filing for benefits at this agency.